Good afternoon, everyone. Today is April 16th, 2020, and this is our bi-weekly community conference call. Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Let's just make sure everybody can hear me okay still.
The conference is now in conversation mode.
Can you guys hear me okay, folks? Can you guys?
Yeah.
Okay, very good.
Yes.
Okay, excellent. Let's go back to...
The conference is now in presentation mode.
So I'm going to begin as usual with answering the questions that I have marked as frequently asked questions. Today was an extremely busy day. I didn't get a chance to read all the questions, but I did my best. If something has been left out of the frequently asked questions, I'll mark it later. But whatever questions have been posted and their follow-ups, I will definitely answer them whatever time it takes. Okay. So that said, let's begin with the first frequently asked question. Effect of a corporate takeover on L1. So I'm a manager of a resourcing company in India, working for more than 2 years in the same company. Recently, a US company acquired us. Can the US company apply for an L1A visa for me and subsequently a green card? And the answer is yes, they can. Let me explain to you how that works. So let's say you are working for company X in India or in any other country. It's got to be outside USA. And a company Y comes and takes over company X. As long as the company Y has a branch or a sister or a parent in USA, as soon as the company X, which is your old company, gets taken over, they become a part of that group of companies. And immediately they can transfer you, both on L1A and, as far as I recall, even on EB1C, on green card. So remember that the relationship between the companies, acquired, acquiring, branch, parent, that does not have to be 1 year old. Only your work for a member of that group of companies must be 1 year outside the USA. I hope that answers your question. *5 if anybody has a follow-up question on this. Press *5 on your phone. Okay. I didn't think so. It's not a very common question, but it is a frequently asked question. Another one also on EB1C is, and this is international managers and executives. I work for MNC, multinational corporation, who filed my green card in EB1C 2 years back. I-485 has been pending 2 years. So he's going to do his portability, trying to move to another company. However, the first employer was in e-commerce, new employer is in banking. And also my new job compensation will be 10% less. I'm not worried about that. I'm not worried about both of them, because even if there were a substantial difference in the salaries, I don't think it's going to be a major issue. Government can say what they want. The requirement of the law is the jobs must be same or similar. The idea that something is similar presupposes that they are not the same. So the fact that one is in e-commerce, the other one is in banking doesn't bother me at all. And I don't think the salary is going to be any problem. The roles and responsibilities will be the same. So as long as the roles and responsibilities are the same, if you are a manager and you are performing substantially the same job duties, I do not anticipate any problem. Now, what documents do you need to provide to your new employer? Your new employer, first of all, don't do it yourself. Get yourself a lawyer. Tell your new employers, if they have lawyers, work with them. You need to file Supplement J. That's what needs to be filed, and it's something that should be assessed by a lawyer before it's filed. Okay. So my current employer suggested to use AC-21. Yes, that's very good, because even if they cancel your I-140, it's not going to be a problem. Once an I-140 is approved and it stayed pending for 180 days, you are covered from every possible angle. But even if I-140 was approved relatively recently, which is not your case, but by the time it was approved, I-485 had been pending 180 days, you are protected from another angle. So in your case, you are protected from every possible angle, even if the employer revokes the I-140. The fact that they are encouraging you is very good. It's generous of them. They should not try to hurt you, which is the smart thing to do for most good employers. Okay. Star 5 if you have a follow-up question on this. Star 5. Press star 5 on your phone. Okay. Let's go on to the next frequently asked question, which, oh, okay, there is a question. And this question is from area code 512. 512, where are you calling from? Go ahead. Which state are you calling from? Hello? 512? I have unmuted you, 512. You can talk. Or Texas. This is from Texas. Texas?
Sir, can you hear me, sir?
Yes, I can hear you, sir. Go ahead.
Yeah, I'm calling from Texas, actually. Yeah, so this is the follow-up question. I have a few questions to the one that you said for EB1C International Manager.
Sure.
So the question I have is when I need to file 485 supplementary. So first of all, when I join a new company, can I go and submit my EAD card and get onboarded? And then subsequently in a month or 2 months, can I file the 485 supplementary? I'm trying to understand what is the sequence of.
The answer is yes. Next question. So it's yes to both.
Yeah, and then you clarified that.
Sir, you can join on your EAD and you can file your Supplement J. See, Supplement J is not required to be filed until the government asks for it. But it's a smart move to do it as soon as you can.
Okay. And then the substantial salary difference, you said, should not be a concern, right? As long as the roles and responsibilities are similar.
I would love to see,
Thank you.
I hope it's not your case, but I would love to see the government trying to justify in a court why during the COVID times they think 10% reduction in salary is a big deal. In general, it is not a big deal in my opinion, but especially during these times.
Yeah, actually, mainly the industry is different. The salaries will be different in different industries, right? So that's the way I'm thinking it should be okay, but I want to just double check with you.
You'll be fine. What else?
Thank you, sir.
You're welcome.
I'm good.
Good luck. Okay, so next question is on I-140 revocation from Nirgun Joshi. I have my I-140 approved 2 months back and the employer is not ready to share the approval notice. So we've talked about this earlier. You should file a Freedom of Information Act request and you can do it online. If you just do a search engine search for FOIA, Freedom of Information Act request, USCIS, you should be able to file and ask for all immigration related documents relevant to your case. You can ask for all the documents and they should be able to give you enough that can prove that your I-140 was approved. Remember, even without the proof, you should be entitled to almost all the benefits because the I-140 is the employer's case and you may not have a copy of the approval, but you are the beneficiary of that case. So the government should cooperate. I'm planning to look out for a job change. Will my I-140 still be there? Well, here is the problem. If the employer revokes the I-140 before 180 days, you will not have a right to extend your H-1 beyond 6 years based upon that I-140. Unless it is pending 180 days, that right doesn't come to you. But if they don't revoke it for another 4 months, then you have the right to keep extending H-1 beyond 6 years. Maybe that's not your issue at all. Because if you don't have an issue with extension beyond 6 years, you're fine. Let them revoke. Even if they do revoke, you can file a new green card and your priority date cannot be revoked. So even if they revoke your I-140 1 day after your I-140 approval, they cannot take away your priority date. That can be transferred to another new green card. Okay. And after 180 days, your wife will also get the same benefit. So even if they don't revoke the I-140 or if they revoke it after 180 days, she will be entitled to H-480. But if they revoke it before the 180 days, then both you and she have to wait until your second I-140 through a new employer is approved. Okay. Star 5 if you have a follow-up question on this. Star 5. Star 5. Folks, I'm going to discuss an extremely important point. And this is important to everyone. I've been asked to do consultations on this, and I have declined because it's such a lengthy topic. But I'll try to summarize it enough so people understand. Many times, I have advised people to apply for B status when they are running out of their current status. Sometimes even when they have already run out of current status. And these two situations are different. This is by no means a perfect solution to your problems, but it is a good solution in the absence of another option. We don't have any other option. So let's say you are in a situation where your current status is about to expire. Let's take the simplest case. You came to USA on a business visa or on a tourist visa, and that's expiring in 10 days. You don't want to travel or you cannot travel. Either way, what do? Well, using Form I-539, which is true for everyone who does an application for B1, B2 status, they have to file I-539. Okay, it's not for every case, but for B1, B2, which I'm talking about right now, tourist status, you have to use this form. And you can do it online without stepping outside your house. Apply for B1, B2. Now, this is where things start getting weird. Pay attention, because it is going to get weird. So when you apply for B1, B2, normally the maximum you can apply for is 6 months status. So let's say you applied on April 15th of this year. You're asking for 6 months, which will take you to 15th October, right? That's approximately 6 months. Now, this is where things start to get weird. The application is likely to stay pending for more than 6 months. So even though you have asked for 6 months, you might get a decision in November, December, or even the January of next year. That's weird, because if you are still here on October 15th, even the period that you have asked for, which is 6 months, is expiring today. So you should file another extension while the first one is still pending. So one thing to remember is to file bridge extension requests if you have to stay longer than 6 months. And the bridge request must be filed before the current status expires, or before the current requested B1, B2 period expires, which is still pending. So the weirdness number one, it takes longer than the period that you have asked for to grant the request. So be prepared to file bridge cases if you stay longer than 6 months. I hope this is clear, because this is an important point. If anybody has not understood this point, and please make sure that other people understand this point. I'll try to extract this part of the video and have it separately for people to share. But this is important for everybody in the community to understand. And when I say community, I don't mean Indian or Bangladeshi or Pakistani or Chinese. Everybody who is in this situation is our community. Everybody who's struggling with status is our community. So please spread it around so people understand. Explain to them that when you file for 6 months stay, remember you need to file an extension before the 6 months are over if you are still here. Okay? If you have not understood this, press *5. It's a simple enough concept. Weird, but simple. Okay. Let me move on to the next step, which is where all the H-1B people are concerned. H-1, L-1, F-1. Every student, every worker or student whose status is expiring is concerned about this part. So let's take the simple example of an H-1B holder. And this has happened today only. I've done like 2 consultations on this issue alone. I'm on H-1B. I get laid off. How much time do I have? I have 60 days or the time remaining on my I-94 to get another job and apply for another H-1B. 60 days or time remaining on my I-94, whichever is shorter. So if my I-94 is expiring in 45 days, but my grace period is supposed to be 60 days, I don't get 60, I get 45 days. What if on the 43rd day I still don't have a job? Well, you have 2 choices. you travel outside the United States and stay out until you're able to get another job, another H-1B, which can take 8, 9, 10 months to process, unless they reposition the premium processing again. The second choice is many people have kids here, or they don't want to travel. They have a compromised immune system, or just they're reluctant to travel. Apply for B1, B2 status. Just like I advised earlier, apply for B1, B2 status within that period, whether it is I-94 or the 60 days of grace period, whatever time is shorter. And you can do it online. Now here is where things get really murky and problematic. While the application is pending and your past status has expired, I declined many consultations on this issue because I don't want to keep repeating the same information even if I'm paid for it. I would rather record it once and have everybody understand it. I've done this before, but I'm doing it again. When your application is pending, but your old status has expired. So take the example, somebody's status is expiring on April 15th, and day before that they had filed for their tourist status. On April 16th, their H-1B has expired. On April 17th, they found a job. The problem is now they can't start working as soon as the application is filed. They have to wait for the H-1B approval, which can take 9, 10 months, which means you're just sitting at home doing nothing. But that's the problem you have to face. So it's not a perfect solution. Remember, I told you, when you apply for a tourist status and the application is pending, you cannot convert from a pending application to another H-1B, nor can you start working. And this is true for L1, this is true for H1, O1, E1, E2, well, not E2, E3, I would say, not E1, E2, E3, any of these visas, or TN, you cannot start working just because an application has been filed. TN cannot anyway, but let's say H1B, L1 of course is also out. But H1 is the most problematic one, H1 and E3. You cannot start working while a B1, B2 application is pending, because pending application after the old status has expired is not considered to be status. It is considered to be authorized period of stay. So there are three kind of possibilities. Actually, there's more than three, but let's take three obvious ones. You are in status or out of status. What is in status? You are a student attending a full course. You are an H-1B working according to the job description. L1A working according to the L1A. True for all visas. This is in status. Out of status is, I had a case yesterday. I have to help that young man. I had a case yesterday. What happened with him was he accidentally took one class more than he was allowed through distant education, remote class. So he fell out of status. Didn't do anything illegal, just a technical error. That's out of status. An H-1B working in a place he's not authorized to work, for example, could be out of status. An L1A who starts working a side job is out of status. Out of status, you could be out of status for 10 years and it may not have any long-term effect on you. That brings me to the next point, which is unlawfully present. Unlawfully present is a very difficult concept to understand. I think there's a 52-page memorandum that the government put out a few years ago trying to explain what unlawful presence in different contexts is. As of today, April 16th, 2020, this is our understanding of unlawful presence. Unlawful presence begins when you have no timely filed application and your I-94 expires. You are unlawfully present. What if you're on H-1B and you did a job illegally on the side, knowingly or unknowingly? That's not unlawful presence. Your unlawful presence will begin when your I-94 is expiring, or when it is revoked. When your H-1B is revoked, the day after that, your unlawful presence begins. But if you have a timely filed application or the 60-day grace period, you're fine. There are some complications there also. So don't expect this to be a complete discourse on every possible angle, but I'm giving you enough information to understand the complexity. So you have in status, doing what you're supposed to be doing, out of status, did something wrong, but still pretty much doing what you were doing. Unlawfully present is when your case is either revoked or your I-94 expires. What is the problem with unlawful presence? After 180 days of unlawful presence, you accrue 3 years bar to come back to the US or get a green card. But you can still get a waiver, something called 212D3 waiver, to come back on an H-1B. That has happened to people we know, our clients. So we get them a 212D3 waiver. After 3 years, that 3-year bar is gone. In the meantime, your green card can still be processed. It just can't be completed. So you do your perm, you could do an I-140. So 3-year bar comes at 180 days and 10-year bar comes at 365 days of unlawful presence. Now you understood that. Being out of status usually has no major complications except for tourist visas, student visas. No complications for H-1Bs, L-1s, O-1s, E-3s typically. Okay. So unlawfully present is the one where you automatically get hurt on the 180th day. When you have a tourist status application pending and it was filed before the current status expired, for example, within the 60 days of grace period following an H-1B, as long as that application is pending, you are in a fourth kind of status called authorized period of stay. It's not full status. It is not unlawful presence, but you're just allowed to stay. And you cannot convert to another status from authorized stay. You have to be in status. So therefore, to summarize a situation of an example of an H-1B holder, I was not able to get a job within 60 days. I filed for a B1, B2 status, went online. I'm okay to stay for the next 6 months unless I file another extension request after that or within that period, as I explained earlier. So I'm okay to stay, but I can't work. I can't work until I get another H-1B approval, go outside USA, get a visa stamp and come back. But if I were representing you and if your lawyers at least tried to push the legal envelope a little bit, for a person in your situation, I would argue that the USCIS must forgive your status problem. They must allow you status within the United States. I don't know if it's legally possible, but it's certainly worth arguing. I haven't looked at the details of this situation, going over the history of the laws, etc., what kind of a case can be built. But I think that's your best shot anyway. It's not like you have 10,000 options. If your status is expiring, 60 days is going, or L1 period, or any of those student status, anything is going away, and you might start accruing unlawful presence. To stop unlawful presence, you have to file a B1, B2, or leave the USA. So what did we discuss? I'm going to summarize what we discussed so far. B1, B2 is not a perfect solution, but it allows you to be in authorized period of stay for up to 6 months. You can apply before the 6 months are over for another extension. Whether or not you get it, as long as the case is pending and it was timely filed, you are not illegal. You're not accruing unlawful presence, but you cannot jump to another status. For that, you might have to go outside USA. But under the current environment, it's a good point to argue anyway. Give me status here, I cannot travel outside. I hope this answers a lot of your questions. If not, now is the time. Let's discuss this fully so the community can be forearmed, forewarned, and prepared. Go ahead, guys. Any questions on applying for B1, B2, being out of status, unlawfully present, what to do? *5 on your telephones. Press *5. Okay, let's see how many people have questions. Surprisingly, only 3 people. So I am most pleasantly surprised that people have understood. Oh no, there's more than that. 4 people. Well, 4 is not too bad. Okay, let's start. So only 4 people have questions. I don't know which one I'm picking first. So let's see. This is area code 408, I guess California. California, go ahead. Area code 408. California? California, say hello.
Hello?
Yes, ma'am, I can hear you. Hello, I could hear you just a moment ago.
Okay, so the situation is here that it is only a matter of
'Ma'am, you
2 or 3 months where
you faded out for a minute, but go ahead. 2 or 3 minutes. What is it? 2 or 3 months?
I'm saying that my H1 has been filed and the RFE has, it gave RFE
Okay.
and it will be, I don't know why my voice is echoing.
No, that's okay. I can hear you fine. Don't worry so much about it. Just tell me what was going on. I can hear you just fine.
So if I file B1 or B2, the thing is what you have told, like 6 months, I'll be like, binded to wait for the approval.
No, wait,
Because
wait,
I
wait,
wanted to
wait,
change
wait.
it
That's
to
a
H1.
very,
It is
hang
a
on,
matter
hang
of
on,
2 or
hang
3
on,
months.
ma'am. Give it a little bit of pause when you talk with me because I can slip in a response early for you. Aren't you the person who did a consultation with me?
Right.
Okay, I remember you. So you made a very interesting point. You said if I file for a B1, B2, I am bound to wait. Not at all. Not at all. So let's say, this is a very interesting point, very important point too. Let's say that you have filed for a B1, B2, and 3 months later, things get better. You just want to go outside USA. By all means, do so. The only ramification, negative ramification is that your application is deemed to have been abandoned. We don't really care about that. Okay. Now, your situation is a little different because I remember your case, your current H-1B has expired. You have an old
Right.
employer with whom you can go and join, but you're not sure they have a job still open for you. And
Right.
and your current employer seems to be a little iffy on the RFE, right?
Yes.
Okay.
Yes.
So in your situation, because your old status has expired, filing a B1, B2 is an extremely imperfect solution. Unlawful presence keeps going even if a B1, B2 is filed, if it is filed outside of current status. When does your current status expire? Well, you are already in authorized period of stay. So even during H-1B
Right.
extensions, H-1B transfers, H-1B amendments, you fall into authorized period of stay when your current status expires and you are living in the United States just because you have a timely filed application for H-1B extension, amendment, or transfer pending. The moment that is denied, you start accruing unlawful presence. The fact that you filed for a B1, B2 does not offer you too much support in that circumstance. Okay, but it is better than nothing. If you are not able to travel, filing a B1, B2 gives you some hope that the government would be kind, be gentle, and give you a B1, B2 status. And remember, if you are unlawfully present, up until 179 days, there's nothing going wrong with you. You can be deported, but they don't have time to catch you. They don't have time to catch criminal aliens. And if you have a B1, B2 pending, the idea of deporting somebody who tried to evade every possible law is ridiculous. I don't think the government should be able to get away with it. So all things considered, there are so many things that can go wrong. In your situation, my first choice would be, and that's why I didn't want you to keep paying me for a consultation. I wanted you to come in so I could record it for everyone. This is such an important issue, and so few people understand this issue. I wanted to make sure that there was more awareness of this, the pros and cons of filing for a B1, B2. B1, B2 is very good to maintain status when you file it within the life of an existing application. It is imperfect when you file it outside the limits. And it is imperfect if you want to go back to work quickly. Does that make sense? Go ahead.
Yeah. Yes, it does. So that's what I wanted to make sure that if the position of mine gets signed within 2 or 3 months,
Mhm.
that is like my another H1 transfer is in process. So I wanted to capture that. Is B1, B2 irrespective of that illegal status and all, if in
No.
case my this H1 gets denied,
No.
then will it be okay for me
No.
to file? That's what
It's
I
not.
wanted
It's
to
not
ask.
a good
Yes.
situation.
Okay.
It's not a good situation. Okay. Why? Because the moment this status is denied, this H-1B is denied, and you don't have a job with the old employer,
Yes.
what is your status? If on the other hand, and I told you this, if on the other hand, you contacted the old employer, said, let me join, I can't move right now. You told me that you couldn't move right now because of the COVID situation. I will move in 3 months. They can, in those circumstances, they can give you an unpaid leave of absence. I got an email from a young man who attended one of our community conference calls. I think it was through another group. He asked me, he says, Rajiv, I saw your quote in Times of India where you said applying for unpaid leave of absence is a good idea. I said, first of all, that's not my quote. Second, I don't think it's a good idea. It's a good idea only if you are asking for unpaid leave of absence for your convenience. The employer can accommodate you, but the employer cannot tell you, hey, take an unpaid leave of absence. I can't accommodate you for 3 months. The project is not starting yet. That's illegal. But it is legal for an employer to accommodate your genuine request. So, in your case, you have the old employer's H-1B approved. You could tell them, okay, I'm joining, but I am not going to move until the situation gets a little better. Is that okay with you guys? And they say it's okay. You are in status. You can start working the moment you move. You can even start working remotely. Okay, you might need an amendment. That's a little bit trickier. But the idea is having an unpaid leave of absence given by an employer at your request for your benefit keeps you in status. Got it?
Okay. All right.
I'm so
Fine.
sorry. It's a
Thank you,
very
Rajiv,
complicated area of the law. That's why I told you I don't want you to keep. You would have to pay me for half an hour of my time, and that's not fair. Because this is really an information that should be open to everyone, not just to you. If it still doesn't make sense, I'll be happy to do a consultation with you. Okay. I don't think you need it because I'm not going to add anything more to it. But if you do, either come back in 2 weeks or ask me now if you have any other doubts. I'll be happy to spend some time with you.
Not really as of now. Like in case if I have anything new, I'll let you know.
Absolutely.
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 Thank you so much.
Good
for
luck.
answering.
All is not lost. You'll be okay. You are one of the lucky ones who has an earlier approved H-1B that has not been revoked. Under the law, you can go back and join that employer anytime you like, as long as you don't violate your status.
Yeah.
Okay. So you are one of the lucky ones. Good luck.
Yeah. Thank you.
Okay. Let's see who's next. I think this is New Jersey. Area code 908. Did I get, oh, hang on one second. Whom did I unmute? Yes, 908. Go ahead. New Jersey.
Hello, Rajiv. Can you hear me?
I can hear you. Yes, sir.
Thanks for your brief overview about the B1, B2 visa, Rajiv.
First of all, let me ask you a quick question. Quick question.
Sure.
Sometimes it's difficult for me to gauge whether I've been understood. Did it make sense? Whatever I said, did that come across as understandable?
Yeah.
Okay, good. Go ahead.
Just follow-up questions from a confirmation. Can't we revoke our B1, B2 application when it's pending?
You can, but what is the point of that?
So let's say my situation is I'm a full-time with one of the healthcare industries, and we will be asking to be furloughed for maybe 2-3 weeks until this COVID situation gets settled down.
Right.
In that sense, if I'm furloughed, will we be out of status, and is there a need for us to file a B1, B2 application?
Okay, now here's the bad part. When you ask for B1, B2, you can't yo-yo in and out of it. Okay, you can't apply for B1, B2 and then go right back to H-1B. That's not how it works. B1, B2 would work only if you have been severed from the job, you've been terminated from the job, and you've not been able to file another H-1B in 60 days, to maintain status, you can file for B1, B1, B2. Furloughing you is illegal. Furloughing an H-1B employee is illegal. Okay. I had a very odd conversation with an employer who was very frustrated with some aspects of an H-1B, and he kept telling the employee, "Well, I'm going to have to fire you. Our lawyers are just getting you fired." I said, "Wait a minute. It isn't my job to assist people in breaking the law. It is my job to explain the law, explain the options for compliance, and let you choose what is required." So now, in this case, if the employer furloughs you, it is not something you are doing. I would argue that you followed along as is required. You were furloughed. 3 weeks later, they continued the job. Well, they are the ones who put you out of status. So I don't think there is any amount of willful non-compliance on your part. Have you been out of status? Yes. Have you broken status? Yes. Have you done it, or has the employer done it? The employer has done it. Okay. How do you get back into status? So let's say 6 months down the line, things get better. Just go outside USA, come back on an H-1B visa. A new one or an old one. Doesn't matter. Okay?
Okay. So 3 options they gave for us is for all full-time employees, it's either a reduced work hours or the flexible furlough option. So let's say I have
Reduced
to
work
do
hours.
0.8
Reduced
FTE.
work hours is 1,000 times better.
Okay.
It's still out
In
of
that
status.
case, do they need to file an amendment?
Well, technically they're not allowed to furlough you, but yeah, for reduced hours, if it's going to last a long time, they should be filing an amendment. But let the employer make the judgment call with their lawyers. I'll be happy to give my input if their lawyers want to reach out to me or their employers want to reach out. I'll be happy to give my input and my idea on what we should be doing. But between the choice of being furloughed and reduced hours, arguing reduced hours as full status is a lot easier than arguing furlough. Okay?
Okay. Okay.
So don't worry so much. You're going to be
Thanks,
okay.
Rajiv.
You're going to be fine. It's only a question of tiding through this really bad period. The way I look at it, first thing you need to worry about is your health, your family's health. And it's not like somebody's going to come and arrest you and say, "Oh, you've done this wrong." This will come up eventually, many months, years later. We'll deal with it. It gets corrected fairly easily. I'm not encouraging people to break the law, but I am encouraging people to keep their peace of mind and know that none of this is irreversible. Okay?
Yep. Thank you.
Good luck. Guys, I can't believe we already spent almost like 50 minutes on this topic, but we do need to. This is something that needs to be addressed. Let me see if there's any other calls. Oh, we covered them all. Wonderful. It looks like people's questions got answered as we kept talking. Excellent, excellent, excellent. I am so glad we covered this topic. So I think I've already covered these 4 questions. That was a lady on the call with me just a moment ago. Let's go on to the next frequently asked question. There's still a lot to do. So what happens if I lose my job after the adjustment of status I-485 interview? I think you're okay, because this is one of those weird situations where you are too close to the edge to file a supplement J, and at the same time you've gone through the interview, everything has been tested. But if I were the lawyer, I would ask you, I would say, listen, do you want to be conservative or aggressive? If you want to be conservative, you lose a job, as soon as you find a job, let's file the supplement J. Okay, that's the very conservative, very appropriate approach. But if you want to be aggressive and say, you know what, I've already done everything I can, I would say at the very least, prepare a supplement J and keep it for your records if this issue comes up during your naturalization. It may not. Ideal thing to do is to file a supplement J if you get your job terminated after the 485 interview and before you get the result, as long as you find another employment. Okay. If you don't have an employment, then we'll have to deal with it at the naturalization stage. Typically, government can go back and say, well, he didn't work for the sponsoring employer. And I would have to say that's not his fault. There are cases on the books that say as long as the employee was willing and he couldn't join because of something to do with the employer, he should get his green card and keep his green card. So I'm not that worried about it. I would like to avoid that situation. It is difficult to plan for all permutation combinations, but what I told you goes. File for supplement J if you already have a job. It may extend your green card processing time a little bit. It's worth it. Okay. If not, be aggressive. We'll deal with it. I think you're in a fairly well defensible legal situation. *5 if you have a follow-up question. *5. Okay. So H-1B visa holders during COVID. So COVID. So during this period, Rick has asked me some questions. I think we have covered most of them, but let's see. Oh, he has some other issues. Is H-1B visa holder eligible for unemployment only if laid off or even furloughed? If yes, how do we know that we are eligible? So this was discussed yesterday. We had a very good, and I must congratulate my colleagues from the DC chapter of American Immigration Lawyers Association. They did a very good job. We were discussing various issues, and one of the issues that came up was the unemployment issue. So the conclusion reached by our joint heads, there were 30, 40 of us, maybe a little bit more, all experienced lawyers from this area. And the conclusion reached was that, first of all, and I have posted a graphic on LinkedIn and Facebook page. I didn't do it on my blogs. I just haven't had time to do everything. So I posted a graphic on who can take benefits, what are the circumstances, who can take those checks that are coming in. So unemployment is a paid for private benefit. Your employer has already paid your insurance for that. As long as the state law allows you to get unemployment, you can take unemployment amounts. Problem is, sometimes state laws say you have to be ready and willing to be able to work in order to get unemployment insurance. The problem is your visa status may not allow that to happen. You can only work for the employer through whom you're approved, or you could be out of status. So you have to look at the state law and discuss it with a lawyer in that state who understand employment law to see if there is a way out. Now, if your employment lawyers want to speak with me about the immigration aspects, I'll try my best to make some time for them. I'll be happy to discuss the immigration consequences. But you can definitely take the state unemployment insurance. Can you take unemployment insurance that is considered under the new COVID relief packages? In my view, you can. I looked at the law and I thought that yes, you can. Because you are a taxpayer. You pay taxes. Okay. Even your benefits checks you can take unless you have a non-Social Security holding spouse. And I put this all in my graphic. So it is my view that unemployment insurance can be taken if the state laws allow it. Where can I check my I-94 expiration date? I-94 expiration date is in one of the two places. If your most recent I-94 was issued upon international travel, you can go online and print out a copy. But if your most recent I-94 was issued within USA as a change of status from, for example, F1 to H1, or as an extension from H1 to H1, you will need to get a copy of the approval notice at the bottom of which the I-94 is attached. It's really a part of the approval package, and your lawyer should cut it out and give it to you. They are required by law to give it to you. That's your property. Okay. So then the next question is, if now I change from H1 to B2 through furlough and want to come back, I think this is the gentleman, Rick was the gentleman we just talked with. You can't do that. You can't just go on to B1, B2 for 3 days or 10 days or 3 weeks or 3 months and then just think that if you abandon it, you're back on H1B. You're not, because you violated the H1B status. Paid time off or combination, I think reducing the number of hours is less objectionable, even though that is, as I said, even though that is not a perfect solution, because typically any substantial change in the job requires an H-1B amendment. If I have to apply for an H-4 and an EAD, do both of them get approved at the same time? You know, they're taking a very long time and they don't necessarily have to get approved at the same time. Would there be a gap in my employment after I switch from H-1 to H-4 waiting for EAD? Yes, there would be. Because if the H-1B is gone and we had to file lawsuits to get H-4 EADs approved. Once we file the lawsuit, it gets approved relatively quickly. But they've been sitting on H-4 EADs for months, 7, 8, 9, 10 months. Okay. So yes, there's likely to be a gap. Any follow-up questions? *5. Press *5 if you have a follow-up question. No new questions. If you have a new question, I won't be able to answer it right now. We have our plate full. We can only answer the questions that have been posted. There's about 20 of them. So this one I think is from Texas. Area code 512, is this Texas?
Yes, Rajiv. This is related to the previous question that I asked for EB1C.
Okay. Don't keep jumping back like that because it's very disruptive, one thing, and second, it doesn't make for a good recording because we want to have all our questions in one place for everybody to listen. In this case, however, that's okay. Just go ahead. But guys, be sensitive to that fact. What is your question, sir?
Thank you. So when I move from my L1A status to new employer on EAD, 485 EAD, do I need to update my I-94 status?
Your I-94 does not need to be updated. There's no such thing. Okay?
Thank you, sir.
You're welcome. Okay, let's go on to, oh, there's another one. This one is from California. No, New Jersey. Go ahead, New Jersey. New Jersey.
Rajiv, this is my question. I spoke to you earlier.
Go ahead.
So here, let's say if I got reduced work hours to work 0.8 FTE, in that case, can we also claim for unemployment benefit?
I don't know how that would work out. Find out what the state law is. What does the state law say about it? If you can get an employment lawyer in that state who's willing to talk to you, we can give him a call, see what he says. I think it's a little complicated. I think it's a question of violation of your status. So I would like to understand what the state law says. Remember, under the rules of ethics under which lawyers work, it is unethical for me to give an opinion about a state where I'm not admitted. Okay, so federal law I can talk about in any state, but where you have a question of state law, I would rather talk with the state lawyer. Okay.
Okay, thanks much, Rajiv.
Good luck. All right, so those were the questions that we had. Now, next frequently asked question. And this one is from Aniket. Aniket, student on OPT. Oh, let's see what's going on here. Oh, there's one more still up. Sorry. New Jersey, are you done? New Jersey? Do you have another question?
Yep.
Go ahead.
No.
Oh, okay, you're done. Got it. Sorry. Okay, so Aniket graduated from UCLA in December last year. OPT started on February 10th, start working on March 30th in LA, coming back to India on 28th March. Flight got cancelled, stuck in India. They said US immigration laws don't allow them to let someone start working overseas. No, look at the frequently asked questions. ICE has put out some frequently asked questions. So there are 3 or 4 different places you can go for frequently asked questions on COVID. So you know that student status is governed by ICE, Immigration and Custom Enforcement, through SEVIP. Okay, SEVIP is the agency that manages your SEVIS. So you go to ICE page, you go to USCIS page, and I also go to NAFSA. They usually have good information. NAFSA.com, NAFSA, NAFSA, National Association of Foreign Students Advisors. I guess that's what it is. So NAFSA. There is a frequently asked question where they said if somebody wants to do their OPT from abroad, they said it's okay as long as the employer has an office. So let's say you are going to do an internship for IBM USA, but you're stuck in India. As long as IBM USA can monitor what you're doing, because you're working for IBM India, that's okay. So if they have a foreign office or an office in your country, you can work for them. And by the way, I did point out to you, one of the lawyers, Jesse, who had filed a lawsuit on behalf of American Immigration Lawyers Association, is actually looking for people who want to become a part of the lawsuit in which we have asked for the government to stop the deadlines from running and to protect the people until 90 days after the emergency is lifted. So stop all deadlines, unlawful presence, OPT, CPT, anything. You want to be a part of that lawsuit, let me know. Just put it on your on the email subject. I want to be a part of the lawsuit, and just describe your situation briefly. Also mention if you have any immigration violations in your past. I'll forward your email to Jesse and see if he can put your name in the lawsuit. It's not going to cost you anything. And it could help everybody. So if you want to volunteer for the lawsuit, come forward, send me an email to help@immigration.com, help@immigration.com. In the subject, put down, I want to be a part of the lawsuit, describe your situation, make sure you tell us that you have any violations, past violations of immigration law. If you do, you may not make a great candidate for the lawsuit, but you still would get the benefit if you win, if the lawsuit is won. So that's what we are trying to get done. Okay. So I don't have anything else to add to this. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question. Okay. Oh, there is a follow-up question. Area code 347. I don't know where that is from. Area code 347. Where are you calling from?
Hello.
Yeah,
this is from New York.
Yes, sir.
Sorry, my follow-up.
Go ahead.
My follow-up question is the last one. If the employer has furloughed and started giving paid time off, so what we can do?
If they have started giving you paid time off, they are paying you for being laid off?
Yes, because we have some leaves, so I believe they will be paying up to the leaves, and I'm not sure after that what they are going to do.
Okay, so I think I have my doubts about this device, but at least it can be argued that you were not out of status. But once that period is over and you're not getting paid, then you're out of status. Basically, you start looking at other options. So what are the options? Looking for another job, B1, B2, what we just discussed. Not too many, unfortunately.
Okay. So in that case, is there an obligation of the employer to inform us in writing
Yes.
that they are going to revoke and we are out of status?
Yes. They don't have to. This is what the employer has to do. Under the Department of Labor rules, the employer has to tell you your job is terminated. The employer has to offer to pay you one-way ticket back to your home country. And they have to inform the USCIS that they are revoking the H-1. Okay?
Okay. So until they tell us in writing, we are not certain whether they have revoked or not.
You just added two words that were not mine. In writing. There is no such requirement. You added those two words which are not a part of the legal requirements. So the employer could say, oh yeah, I called him, I told him. It's your word against their word. If I were representing the employers, I would tell them, put it in writing. I don't want you to just call them and say you've been terminated. Just say, look, we have to let you go from start date of XYZ. And by the way, we can offer you a ticket back to your home country, not your whole family, just you, and not first class. We can offer you an economy class ticket back to your home country. That should be in writing, but it's not required by law to be. Okay?
Okay. So that means I cannot hold them back unless if they have not given me in writing.
Well, you know what you can do? You can send them an email saying, I haven't heard anything from you. Am I fired? Isn't that a good way to do it?
Okay.
What does that show? It shows that they never told you.
Yes.
Okay.
Yes. But in that case, it will raise alarm for them, and they may write back, yes, you are.
So let them raise the alarm,
problem.
but then you are fired from that date, and then you have 60 days from that date, right? That's what I would argue.
Okay, understood. So I will try to contact them on the 50th day.
Absolutely.
Maybe that's to be on the safe side.
Absolutely. Okay.
Understood. Thank you.
Good luck. Okay, guys, please, I request you not to keep going back. Let's just keep moving forward. But at the same time, I do understand if you have to, but try to, ask me the questions when I'm dealing with them. Okay, so we dealt with the frequently asked questions. We're already about an hour and a half into the call, but that's okay. Let's just go on to the non-frequently asked questions. So that starts from, let's just make sure. Oh, no, there are a couple here I was going to miss. Okay. First one is from Jim B627. I'm an American citizen. Husband is Canadian. Married in the US in 2014. Have a 4-year-old son together. US citizen. We go back and forth to Canada. I've got Canadian permanent residence. Moved there for 2 years. Moved back to the US with our son. We filed I-130, 131 forms. I'm not sure what the 131 is for. Would love for my husband to be able to live with us while we wait. So that's a little complicated. Why? Because if he enters USA without revealing that he is coming for change of status or adjustment of status, they can say he came in fraudulently. Okay. But if he declares at the airport or at the border, look, I'm going to go there and be with my family, and we are going to apply for my 485, is that okay if I come in? If they let him come in, great. But if they don't, then they don't. Okay. So, see, technically the problem is there are cases and there's a history where government has been told and government has itself said that we don't go after immediate family members of US citizens when they come in on a tourist visa and apply for a green card. But I've just finished doing somebody's appeals and motions to reopen, and I think finally they are in court, where somebody's parents, US citizens' parents from Philippines were told, oh, you have committed fraud in coming in on tourist visa. And I said, what the hell? You can't take that approach, because look at your own regulations and policy. You're not going to hold US citizens' parents or US citizens' spouses to that standard. But under the Trump administration, they're trying to do everything they can to make things difficult for people. It's interesting. When Trump needs chloroquine, he goes and makes a request to Modi. But when they want to bother and to push immigrants around, they do whatever they want. It's an interesting dichotomy, and I personally think it's ridiculous. Nevertheless, that's where I don't want to bring my politics into it. But the point is that you have a very weird issue. They should not be stopping your husband from coming in and applying for adjustment of status, after which he can stay here while his green card is being processed. At that point, 131, etc. become relevant for travel. Okay, but right now there is no easy solution. The best thing he can do is if he declares at the airport or at the border, hey guys, I'm going to go in and I'm going to apply for my green card through my wife. Is that okay? Because she's already there and I want to stay with them. If they let him come in, he's 99.9% safe. I won't worry about him. But if he comes in without that declaration, I think government can say it's fraud. So he should wait outside, keep coming back in and out as he does now. Once his green card is approved, he can move here permanently. You can also apply for something called a K3 visa. If that comes in earlier, it may not, because the green card might come earlier than the K3. So you can apply for a K3 visa as well. Okay. *5 if you have a follow-up question. *5. All right. And this one is from area code 781, and I don't know where that is. Area code 781, where are you from? Area code 781. I can hear you.
I'm from Massachusetts.
Hello, Massachusetts. Go ahead. How can I help you?
Hi. I just wanted to say thank you. That was my question, and we've been pretty confused.
Oh, no,
so
no worries
that
at all.
helps clarify
Hey,
it.
I have a very special place in my heart for Canada. I went to school in Ottawa, and I loved living in Canada. It's a fun country to live
Thank you so much.
in. Good luck. Yeah, Canadians are delightful people. Okay, so next question. This is an easy one relatively. Can an immigrant who worked under the guise of a US citizen still considered for adjustment of status? And the answer is, it's not an easy answer. If somebody tries to get some benefits pretending to be a US citizen, that's a ground for keeping them outside the US. Now, there could be all sorts of exceptions, and I'm sorry I don't have all the answers off the top of my head, but you can actually go, and it's very, very nicely covered in the adjudicators field manual. So if you go to the USCIS website, uscis.gov, on the extreme right, I think they have something called the laws. Under the laws, they have memos and policies, and under the memos and policies, they have adjudicators field manual. And under that, they have a chapter on admissibility, who can be admitted to the US. And in that, there is a very nice write-up on how they determine how they will keep somebody out. You must have lied intentionally, you must have lied to obtain some benefits. There's a whole list of requirements. Go look at that. Okay. I have nothing else to add to that, so I'm not going to invite a follow-up question. *5, oh no, sorry. That was just reflexive. Go on to the next question. So this is from, oh my God, we're still at question number 8. My H-1B was valid till 2022. I quit my job in 2020 to go back to India. Due to COVID travel ban, couldn't fly back. 2 flights cancelled. 60 days grace period is ending April 12th. Absolutely, you heard the entire spiel on B1, B2. I've got nothing else to add. This was an easy one. So listen to the B2 discussion. Follow-up question, press *5. Follow-up question, press *5. Oh, great. Yeah, we already covered this. Aged out children. Is there any provision for disabled kids to stay with parents after they turn 21? Absolutely. B1, B2. There is a provision in law that says sometimes, and this is in Foreign Affairs Manual, which is the standard operating procedures of the State Department. There's a provision that says sometimes people are not qualified for a derivative visa like H4 because they aged out, but they still need to be with their family. In those cases, we will consider extending B1, B2 on a 6-monthly basis forever. I mean, I don't know about forever, but I've got cases where I've been doing it for 5 years. I have one person, very sad case, but very strong wife. They have been in this country for 5 years because he had a stroke and he's still under rehab. And we keep extending their visas every 6 months. *5 if you have a follow-up question. *5. Next question is from Kevin, who says, when I applied for 485, I needed a co-sponsor. Now I don't. I have enough money. I would just turn in your 2019 tax documents, and if the government asks for them, I think it's a little tricky. It's kind of difficult to predict how this will go, because the government can say, when you filed the 485, you must have the ability to pay, the ability to support her at that point of time. Okay. So if you subsequently developed the ability to support her, they could try to disregard that. So ideally, I would want your aunt to complete the papers. But even if you don't, but your current income reflects that you had that ability even when you filed the case, you should be okay. But if the ability came later, government can disregard it. So it's best to actually do both. *5 if you have a follow-up question. *5. Okay, now this is about a husband being a naturalized US citizen. We met while we were studying in the US and got married in 2007 for more than 13 years. Husband petitioned, I got my green card. He got a job in Oman. We moved to Oman in July 2008. I went back to Oklahoma to finish my dissertation, off to join my husband in Oman. Haven't been back to the US. So your green card is gone. Okay. We want to move back to USA. Now, you can't really, I don't think you can do an SP1. You will have to file for a green card all over again. Now, here are the tricky steps that you got to follow. So listen closely. First thing you have to do is, in my opinion, there's no excuse for you other than just living in Oman with your husband. Unless your husband has some very special circumstances, he would have to file your green card again. Might take a year, 2 years for it to process. When it is time for you to interview for the final step of the green card, he must either already be in USA or must be in the process of moving to USA. That's important to realize. So file green card. Somewhere towards the end, he has to move to USA. What if you wanted to move to USA while the green card was going on for the kid's sake? We had a case exactly like this. Exactly 100% the same case. So in that case also the husband was the US citizen. We were able to file her green card and have her go into the consulate to get a tourist visa, fully disclosing that a green card was going on, stating that her children needed to be in USA to continue their schooling. They didn't want to miss a whole school year. So if in the middle of the year you give me my green card, my kids suffer. They are both of them US citizens. So the consulate was very understanding and they gave her a tourist status. And when she came to USA, because she had fully disclosed she had a green card going, we were able to file for an adjustment of status for her in the United States. So tourist status could work. It doesn't always work, but it might. *5 if you have a follow-up question. *5. Okay. So, okay, great. We have 3 questions already covered. Question number 15. I came to India for H-1B stamping. They sent my case back to USCIS for revocation. Today I got an email stating that we're going to revoke. Employer filed a new petition under cap exempt. It got approved. Okay, that notice of intent to revoke doesn't affect you. Why? Because you don't need the quota. You are under quota exemption. Unless there is some fraud claimed against you personally, that revocation is not going to hurt you at all. So you're fine. *5 if there's a follow-up question. *5. Irfan says, laid off March 18th on H-1B, which was good till 2022. I-140 approved, more than 180 days. Also submitted 485, wonderful. EAD and AP is approved, you're all set. Planning to join new employer on green card EAD, which is less than 180 days. Okay, I had a very weird case. I'm going to talk to you about this in a second. Also a Muslim guy. Why that is important? Because the lawsuit that was filed, it was claimed that being Muslim has something to do with them trying to come after him. So let me explain to you in 1 second. I'll tell you what happened. I have I-140 approved with the same employer, which is more than 180 days. Submitted 765. Oh, I see. But how long is, you submitted in November 2019. Okay. So December, January, February, March, until 180 days are over. So this case that I'm talking about out of Michigan was exactly like your case. The government came in and said they wanted to revoke or deny the 485 because he changed employments before 180 days of 485 were up. And we said, that's ridiculous. You can't do that. So we gave them a memorandum of law that the law doesn't require you to hold that job for 180 days. Just that the 485 should remain unadjudicated for 180 days. Okay. The government denied the 485. Lawsuit was filed. The government settled within 2 weeks. They gave him his green card. So I think you are okay as long as the I-485 stays pending for 180 days. But don't start a new H-1B until 180 days are over. You can after 3-4 months. Okay. So once you apply for an H-1B to get back onto H-1B status, remember, if you hear the earlier discussion, you are in authorized period of stay. To get back onto H-1B, you'll have to go outside USA, get a visa stamp, and come back. Can you work multiple jobs on green card EAD? Yes, you can. As long as you have one focused job, whether you have another company on the side you are working for, or your own company, or consulting, or doing anything that you like, that's fine. As long as you have a main focused job, full-time job in your field, same or similar. Star 5 if there's a follow-up question. Star 5. Okay. Arpit says, I got picked up in 2019 H-1B lottery, went for consular processing, got laid off before I could convert it into H-1B. Is there a petition that can be filed with my future employer to help use my picked up lottery? Okay, this is an interesting problem. And please, guys, don't call me Mr. Khanna. Just call me Rajiv, please. It sounds weird. Okay, so the way this works is, government says, until you get H-1B visa stamped or change of status to H-1B, we don't consider you to be exempt from the quota. I think it's nonsense. I think it's against the language of the regulations and the laws. Nevertheless, that's what they claim. But they've never pushed us on this. So if I have somebody in your situation, got the H-1B approved but didn't get the H-1B stamped, okay, I have been able to get them without the quota so far. I have several cases like this. So our team has not had an issue, but I warn you that they can make an issue. So if you have the choice, also keep applying for H-1B lottery every year. Okay. Star 5 if you have a follow-up question. Star 5. Question number 18. Parents' green card. Background, I'm a US citizen, India born, received green card via EB2. Parents sponsored, live in India, I-130 approved. We are putting together IH-64. They have a B1, B2. If my parents need to travel while their green card application is not completed, can they enter the US on B1, B2? I've taken this question before, and what I've said is that at the airport, they can turn you back. They can turn your parents back. So if they want to do it, there's no law that specifically requires them to be turned back. In fact, that's a very schmucky thing to do. But this is the government of schmucks, so I would not expect them to behave decently. So what I would do is, I would come through the Middle East. There are flights that stop in the Middle East, and you can get your immigration clearance in USA for USA done in the Middle East. So if they are turning you back, you have to fly back only 3-4 hours. You don't have to fly back 20 hours. That's what I would do. Don't cancel their green card. Canceling the green card doesn't take away the problem completely. And try not to switch to adjustment of status. I discussed that briefly because they look upon this as fraud if there's a preconceived intention. If they are here and after 3-4 months they want to understand if adjustment is a possibility, you can explore it. But do not bring them in with a preconceived intention. Don't let them get their birth certificates and all beforehand, because this government has been creating problems with this. Sometimes they don't, but there are officers who are doing it and we are fighting them. Star 5 if you have a follow-up question. Vishad has a question about unemployment, and we discussed that already. So you said, if unemployment benefit rules are different for different states, this question is specific to Massachusetts. And I said, I cannot comment about the state laws. I'm not admitted to practice law in Massachusetts. DC and Virginia, but even there I don't know what the employment laws are. Okay, sorry. So last question for today. Guys, I'm not going to have time for new questions. Unless something is very, very urgent and you need the answer today. Let's wait until 2 weeks from today. So keep that in mind. Don't ask me a question that can wait a couple of weeks, but if something is urgent, I'll take your questions. Last question is, I got laid off. I applied for H-1B transfer before 60 days. Very good. There is no rule that you can legally stay in USA for 240 days. There's no such thing. Not so far. The 240-day rule is this. If you file for an extension without change, you can continue working with the same employer for up to 240 days after your current status expires while your extension is pending. If you join an employer, it's a transfer case or an amendment or an extension without change, with change, not without. You can continue working as long as the case is pending. *5 if you have a follow-up question. *5. Oh, there are more questions on the next page. I didn't see that. Okay. Wow. I thought I was done. I'm not going to have time for new question, guys. Okay. This is from California. California, you have a follow-up question. Go ahead, please.
Hi, Rajiv. This is a new law which I saw in the USCIS website for the COVID-19 delays in extension and change of status.
No, there is no.
So when they say that we can legally stay for 240 days.
No. I don't know where you are getting that from. There has been no change in that law.
This is from USCSC.gov.
No. Listen to me. I don't know again where you can email me. Do me a favor. Just email me your question with the link help@immigration.com. The 240 days period was already there in the regulations, which said that you can continue working on H-1B if you file an extension without change for the same employer. With change, there is no limit. But without change, there's a limit of 240 days. Send me an email, help@immigration.com, put your phone number there. I'll look at it, I'll give you a call back. I'm always willing to learn something new. I do not believe there is anything like that. Okay?
This has been done in the recent past.
Sir, I keep track of developments by the hour. Okay.
Okay.
I keep track of my only
I'll
job.
send an email. I'll send an email.
Something is not right. Either you are misunderstanding something. It's possible I could have missed something. Very unlikely, but I'll take a look at it. Okay.
Sure.
All right. So I didn't realize there was a bunch of other questions also on the next page. I thought I was done. Wow. Oh, gee. Oh, Lord. Guys, I'm not going to have time for new questions. There are 26 questions. Normally I do 12 or 13. I'm not going to have time for new questions. I'm sorry. Who's raising their hand? Area code 650. What is your question?
Hi. So my question is last question on the second page.
Okay.
I just wanted to get your feedback if I were have to, which process would be faster if I were have to file my family-based green card with my brother or with my parents?
First of all, why do you have to choose? File everything that you can. You can have a green card going in 10 different categories. But by the way, parents of green card or green card holding parents cannot apply for married children. Okay. I'm looking at your question. So obviously, your parents cannot apply for you until they become US citizens. And you can file for a green card in as many categories as you like simultaneously. Okay?
Okay.
That's it. Good luck.
Okay.
Bye-bye.
Thank you.
Okay, that was easy. So let's go back to question number 21. EB1 filing from Vikas. I'm in US as an H-1B on H-1B as a manager with few IT contractors reporting to me. Supporting my company is a manufacturing company. If I go out of USA for a year to India and work remote from there on same manager position, still getting paid in USA, I don't think it would work. I've looked at this issue for another client of ours. I don't think it would work because the law requires you to work outside USA. And I think, well, let me rephrase that. Employer-employee relationship must exist. So I have a case. Let me give you an example. This is a different case from the one that I researched. But I have a case where one of our executives is working from UK. He reports to the global CEO in USA. His salary is being paid through USA, but UK is reimbursing USA for that salary. Now, I think that case I can make because the employer-employee relationship through payment exists with the UK company. They are reimbursing the US company. So here, I think it's difficult to establish, and I would hate for you to go outside for 1 year and not be able to have a surer case. If you go outside USA, 1 year, you are working on projects that are exclusively in USA. You're getting paid through USA. With whom do you have an employer-employee relationship? Okay, so I think I think it's an untested area. If you are willing to be a test subject and try it out, you can certainly do it, but I don't think it's likely to work. Somebody raised their hand from California. Yes, California, go ahead.
Hello, Rajiv ji. This is Vineet Neji. I spoke to you like a couple of days back about my dad's travel to India when his GC was in process, right? So I just want to let you know that his GC got approved.
Oh, good.
And yeah, Rajiv ji. So. Yeah, his GC got approved, and we didn't even need to go for it.
Yeah, what they are doing is that's one good thing out of this COVID situation. Many cases they are approving automatically without an interview. Okay. Now, parents' case, you can always even ask for a waiver. But the fact that they are doing it without interview, that's wonderful. Well, thank you for sharing that. Good luck.
Yep.
All right.
Thank you, Rajiv. Rajiv ji, I have just one question. So now I'm planning to file a GC for my brother.
Right.
And I just wanted to know that is it the same process which I followed for my parents and I consulted you for the same?
Same process. I-130, then wait 15 years, and then they come.
Okay. All right. Sounds good. Thank you very much.
Bye. So back to Vikas. Vikas, are you on the phone? Do you have a follow-up question? *5. Okay. Then the next question, number 22, is there are 4 questions. H-1B approved. I'm on H-1B, I-140 approved with the current employer. Extension has been filed. The current petition expired in December. Received an RFE. They are responding with a statement of work from the current client. My client just notified the contract will be ended. Since it's an RFE, should I proceed with responding with the current client's SOW? Absolutely. 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 And also, tell your lawyers to argue from the IT Serve Alliance case that the court has said you can't deny cases just because they don't have an SOW for the entire period. If the employer says, I'm willing to pay the employee their full salary, you shouldn't stop the H-1B process approval. So have your lawyers argue that. In case of a denial or 240 days elapse, what are my options? B1, B2, listen to that discussion. So really, after this, if this is denied, you will have 60 days, but I'm sorry, I take that back because your I-94 is already expired. You have probably a 10-day grace period, if that. I have to look up the law on that too. But you definitely don't have a 60-day grace period. And in any case, when there is no bridge petition bolstering your status, I doubt very much that you're protected from getting out of status or unlawfully present. So I think in your case, responding vigorously to the RFE and then be ready to go to court over this if you have to. Okay. *5 if you have a follow-up question. *5. Okay. So, wow. This is question number 23. H-1B expired, timely extension filed, got RFE. Oh, we already answered this question. We talked to her. Yeah, we talked to her. Okay, so this is done. Then number 24, I'm on H-1B valid till August 2021. I-94 is till May 2021. Laid off by the employer without any written communication. Yeah, that's not, they are required to pay you for that. You already talked with me. We've already discussed this. Good. So STEM OPT got followed for 6 weeks. And my problem is I am so uncertain about laws of other states. And also remember, by the way, STEM OPT allows you to be out of status for up to 60 days, right? So you could probably skate by for 60 days. As far as applying for unemployment benefits is concerned, double check with the employment lawyers in the state. And like I offered to somebody else, if the employment lawyers have a question about immigration status, they can call me. But I can't discuss the laws of another state where I'm not admitted. Can I work for another company which is in the area of my study? So STEM OPT, you've got to do the revision of the, 981 or 983, whatever that form is called. So yeah, you can always change employers, but you've got to notify your International Students Office within 10 days, something like that. So check with the DSO, and yeah, you can always change company. Can you keep switching back one from the other? I think so. I don't know of any limit why you can't keep switching back one from the other. Okay. So about the furlough, I think you should inform the DSO. I think you should, because remember, you have to report any substantial change in your job to the DSO within 10 days. So I think, yeah, this should be reported. Will this, the unemployment benefit affect your future life in the US? As far as I can tell, no. And again, remember that the public charge issue is an issue of totality of circumstances. So whatever happened during this time, I would be surprised if it becomes an issue. Let's put it that way. Can I guarantee it? No. Do I think it's going to be an issue? No. *5 if you have a follow-up question. And the last one we've already discussed. Okay, guys, even though I'm running out of steam completely, but I do want to make sure that there's nobody left who's got an urgent case. So if you have something very, very urgent that can't wait 2 weeks, press *5. Okay, we got one. Excellent. One I can deal with, no problem at all. So this is from area code 347. 347, where are you from? Which state?
Yeah, Rajiv, this is New York. I'm from New York.
Yes,
I have one last question. Like you said, if we apply for B1, B2, and H1 is laid off after the expiry of the 60 days,
right.
We cannot go back to H1 again. And it's a long process. It takes 6 to 9 months, you said, right?
Right. Unless they reinstate premium.
Is it a good option to...
Right, unless they reinstate premium processing, in which case.
Hello?
Yeah. Go ahead.
Unless what?
Unless they reinstate premium processing.
Okay, yeah. So, is it a good option to, instead of applying for B1, B2, to convert to F1, and from F1 we can convert to H1 easily?
No, it's the same, absolutely the same circumstance. There's no difference at all.
Okay, so there is no benefit to going to F1.
Same problem. While the case is pending, you are in authorized period of stay. To convert back to H-1B, you've got to go outside, get a visa stamp, and come back. So it's no difference between B1, B2, and F1. Only advantage is F1, you can start going to school.
Okay. But otherwise, it will not help for H1 reinstatement.
It will not. All right.
Okay. Thank you.
Good luck. Okay, guys, hang in there. I will see you again in 2 weeks. No worries. Good luck and thank you so much. I always enjoy talking to all of you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away, and post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.